Court's going to start with a matter on the Baxter County Criminal Docket, CR 2017-310, State of Arkansas versus Adam Wetstein. All right. Mr. Wetstein, you're appearing at this time for purposes of changing your plea on the charges against you. Is that correct?
Yes, sir.
And this change of plea is brought about by an agreement that's been worked out for you by your attorney, Mr. Wilbur. Is that also correct?
Yes, sir.
Have you discussed the terms of the agreement and the punishment you're to receive with Mr. Wilbur?
Yes, sir.
And do you feel you understand what the agreement is?
Yes, sir.
Are you satisfied with the advice and the representation you've had from Mr. Wilbur?
Yes, sir.
Can you say that louder?
Yes, sir.
On the charges as they're being amended by this agreement of possession of a controlled substance, methamphetamine, Class C felony, possession of a controlled substance with the purpose to deliver, LSD, a Class C felony, and possession of a defaced firearm, a Class D felony. On those three charges, how do you now plead?
Guilty.
You're aiming this plea of guilty pursuant to an agreement, or the agreement. The agreement in this case is set out in writing on the document I'm holding up here called the plea statement. Have you read through and signed this plea statement?
Yes, sir.
Do you feel you understand what's set out in the plea statement?
Yes, sir.
You then understand the nature of the charges against you and the full range of penalties you're facing?
Yes, sir.
You understand that by pleading guilty, you're giving up certain constitutional rights that you possess?
Yes, sir.
The most important of the rights that you're giving up are the right to a trial by jury. You're giving up the right to have an attorney who represents you throughout that trial process and assist you in preparing and presenting your case. You're giving up the right to confront witnesses that would appear and testify in court against you. And you're also giving up the right to appeal. All of those are rights you give up by pleading guilty. Do you understand that?
Yes, sir.
And understanding what rights you're giving up by pleading guilty, are you still willing to plead guilty?
Yes, sir.
Are you pleading guilty here today freely and voluntarily?
Yes, sir.
Has anybody in any form or fashion forced you into this plea?
No, sir.
As you plead guilty here today, are you admitting to your participation in the crime involved?
Yes, sir.
Are you admitting that on or about the 22nd day of June in 2017 here in Mountain Home, Arkansas, that you were involved in the that you had in your possession both a quantity of methamphetamine and a possession and also a quantity of LSD for the purpose of sale, and that you possessed in your possession also was a defaced firearm?
Yes, sir.
Okay. Based on those statements, the court formally accepts the defendant's plea of guilty, finding that he has freely and voluntarily entered his plea of guilty, done so after consulting an attorney, and has admitted to his participation in the criminal activity involved. On that basis, the court accepts the defendant's plea and will sentence him in accordance with the agreement to 5 on each of the 3 felonies to 5 years of supervised probation, subject to the standard terms and conditions of probation, with those sentences running concurrent with each other. Excuse me, I overlooked. There's a fourth count, possession of drug paraphernalia, Class D felony. Are you also admitting, pleading guilty on and admitting? How do you plead to the charge of possession of drug paraphernalia?
Guilty.
Are you admitting, again on that same date, that you had in your possession drug paraphernalia related to the use of methamphetamine?
Yes, sir.
Right. The court is going to accept his plea on that charge as well, find the defendant is guilty of possession of drug paraphernalia, Class D felony, and impose the same 5 years suspended and placing him on 5 years probation, subject to the standard terms and conditions of probation. And again, that fourth count will run concurrent with the others. The The court is imposing a $200 fine, $200 court cost, $2,000 fine, the statutory DNA fine of $250, the bullion administration fee of $20, and a drug crime assessment of $125, with all of those amounts due and payable as a term and condition of his probationary sentence. Payments to be made starting within 30 days of this date of at least $100 per month and continue until the full amount is paid. That'll be the order of the court. The defendant is being placed on probation subject to the standard terms and conditions of probation of this court. Those terms and conditions are attached to the plea statement. The court has read them over and signed them, making it the order of the court that the defendant comply with those written terms and conditions of probation. And the defendant himself has signed them, indicating that he has read, understands, and will comply with the terms and conditions of his probation. At this time, I'm going to direct that the defendant will meet with the probation officer and get set up on probation. You may be excused to do so.
Good luck. Thank you.
2017-320 State of Arkansas versus John Fisher. This case was down on a scheduling order for pretrial today. It's a district court appeal.
Yes, Your Honor.
Yes. All right.
There are no motions pending for today, Your Honor.
All right. His appearance is noted. The fact there are no hearings to be held. The next appearance date, according to the scheduling order, is the plea deadline date, which is that April 19th date, and we'll, if that changes, we'll let you know.
Your Honor, we had requested previously, will you waive our appearance for simply for the plea rejection date on the 19th if we submit something in writing to the court? Is that acceptable?
Yes.
Thank you, Your Honor.
Be glad
and
to do that.
Let the prosecutor know that week of the 23rd to 24th, I do have court already scheduled. That one Tuesday, I'm not available. If that means continuance of the whole week or just unavailability that day, I don't know how this court handles that sort of.
Well, what I'd ask you to do is communicate with I expect you to communicate with the prosecutor's office.
Yes, sir.
About dates, your availability, and because they're going to be setting the cases that
Sure.
week in accordance with priorities. If we have a child rape case or something like that, it's going to get priority probably over this case.
Sure.
But they'll be the ones who are determining the trial order, and so if you'd communicate
Yes,
with
sir.
them and see if we can't come to some agreement on a date.
I'll call Ms. Copeland's office later this week.
All right.
Or next.
All right, very well.
Thank you, sir.
very
For
much. You
considering
may
me.
be excused.
Thank you for consideration.
Court will call 2016-190, 2017-224, State of Arkansas versus Charles Franks. Let me see. Where do we stand on?
Your Honor, Mr. Franks had previously, my understanding is Mr. Franks had previously appeared before the court and entered pleas of guilty in these two matters, and was sentenced, and then subject to his being released pending the availability of space in his reporting. And I believe what has happened is that for whatever reason, Mr. Franks failed to report when initially required to do so. At this point, if it pleases the court, there are a couple of FTAs, and because there's one in each matter, the state's willing to forgo that. At this point, believes the quickest, most efficacious thing would be if Mr. Franks simply was remanded to the ADC to serve the sentence that he was already imposed.
I've already imposed sentence, right?
Yes, sir.
Okay, that's why I was just checking. This court at this time will notes the failure to appear warrants that were issued. Mr. Franks is now in custody, and those warrants can be quashed. At this time, the court is going to sentence the defendant in accordance with as the court already did back in January, and he'll be held to serve those sentences. I believe it's 8 years.
I think it may be 10 years, Your Honor.
Well, one of them at least.
I'm sorry.
I think there's I'm only got one of the two cases up at this point. So,
I'm sorry.
well, The sentence previously imposed is he's already sentenced on, and the court, he's to be held for in the county jail until time comes for him to appear. I mean, him to be transported. That'll be the order of the court. You may be excused, Mr. Franks.
Thank you, sir.
Uh, 2018-76, State of Arkansas versus Rebecca Briniarski, and 2016-400, same defendant on a revocation case.
Your Honor, on the, has she been arraigned on the revocation?
Now let me go check. It does not appear to the court she has been. The petition to revoke filed February 26, 2018 contains the allegation that she had violated the law. I guess that may be case 2018-76, where it's alleged that she committed the offense of possession of controlled substance, 2 counts, plus 2 counts of drug paraphernalia endangering the welfare of a minor. It's also alleged in that petition that she violated the condition that requires her not to have any controlled substances, and again, it relates from the February 15 allegation that she was arrested on for having controlled substances in her possession. On those charges, how does Ms. Briniarski plead?
Your Honor, she would enter a plea of not true.
That plea is noted on the record. Let me get back to the other case. Today in case 2018-76, this was her reappearance on a scheduling order to check on the status of the case. She's got a pretrial date on May 3rd. She's got a plea deadline hearing on July 12th, and it's set for trial during the week of July 16th.
Your Honor, the only action to take on either of Ms. Briniarski's cases today is the state and defense have agreed. I've made the state aware that Ms. Briniarski is 32 weeks pregnant, and that's been verified by Sierra, the nurse at the jail. So based upon that and based upon her cases in general, we've agreed that her bond would be set to cover both cases at $5,000 cash or pro.
Your Honor, there would also be the understanding, I mean, since she does have a pending revo, she still needs to be reporting probation. She needs to get.
All right.
as soon as possible.
In light of the circumstances, the court's going to set the bond at $5,000 cash or pro, conditioned upon her making that bond that she report within 24 hours to her probation officer. If it comes on a weekend that she's released, the court would order that she needs to be in the probation office no later than 10 o'clock on that Monday morning, and actually make contact with her probation officer and continue with regular communication based on the fact that she's on probation. That will be a condition of her bond. The court's going to set that May 3rd date as a potential date. That's a pretrial date in 2018-76, and in 2016-400, that's the date the court is setting the matter down for a hearing. Court's going to note a waiver of the 60-day requirement by the defendant.
No objection, Your Honor.
Your Honor, additionally, I just briefly discussed with Mr. Cooper that the state would like to also state that there will be drug testing as a condition of the bond. A little concerned about the nature of the charges and her health status at this point.
All right. Court concurs in that the drug testing will be a condition of the bond. Right? You may be excused at this time.
Thank you, Your Honor.
2017-198, 2017-383, 2017-391, 2018-43, and 2018-48, State of Arkansas versus Ryan Kinsley. Danishevsky. Danishevsky. All right. I'll do my best, sir.
That's all right.
All 5 of these cases are on the docket for today. On 2017-383 and 391, the trial date is that week of April 23rd, with pretrial with the final plea deadline on April 19th, and today was the pretrial day on those. That's the way I think I believe it. Or maybe it's in March. Keep going back and forth because my memory's not that good. On the latter 2 cases, the trial date is July 16th, final hearing on July 12th, pretrial on May 3rd. That's the way I have it, at least the looking at the file and the docket. Are these cases going to trial or ready for trial, or where do they stand in terms of trial preparation?
Your Honor, I think that they're on track. I don't ask for any change in the scheduling order today. The state yesterday and then again this morning, Your Honor, we will be submitting an order to you later today with an agreed upon bond amount between the state and defense.
That's correct, Your Honor.
I take it then there are no pretrial motions pending for today in the first 3 cases?
No, Your Honor, there is not.
No, Your Honor.
All right. Well, what the court's going to do is enter a scheduling order that sets 2017-198 for trial on April 23rd with a plea deadline date of April 19th. That's already the trial date and pretrial date for, plea deadline date in case 2017-383 and 391. In case 2018-43 and 2018-48, the trial date is the week of July 16th. Plea deadline date is the week of July 12th. And the pretrial date in those 2 cases is May 3rd. So that's just to clarify. You know, we have 5 cases here and we have different dates, and I'm just trying to make sure the record's clear on when everything's set for trial. At this time, is there anything further to be brought before the court?
No, Your Honor, there is not.
All right. All right. You may be excused, sir. (2018-32) State of Arkansas versus Brandi Barnes. This case is before the court today for a reappearance. The pretrial date on the case is May 3rd, and the trial setting is for a plea deadline on July 12th and trial during the week of July 16th.
Your Honor, there is no action from the defense to take on this matter today. I will tell Mr. Barnes that I will see him very soon at the jail. Your Honor, for some reason, I thought that this was a conflict case and was assigned to one of our other attorneys. Mr. Barnes, I now realize it is my case, so I will get over and see you, all right?
Yes, sir.
All right. Nothing further to do today. You may be excused.
Thank you.
2018-78, State of Arkansas versus Tyler Hutton. Court makes the appointment of the Public Defender's Office to represent Mr. Hutton. This case is, he's already been arraigned. This case is down for not only reappearance today on the scheduling order, but pretrial on May 3rd, plea deadline on July 12th, trial during the week of July 16th. Anything else to come before the court?
Your Honor, there is nothing else. When I visited with Mr. Hutton yesterday at the jail, he advised me that he's currently in the process of a 90-day PV, so there's no issues of bond or any other issues today.
All right. Mr. Hutton, you may be excused.
Thank you.
2018-72, State of Arkansas versus Michael Wood. Mr. Wood, do you have an attorney representing you at this point?
No, sir.
Okay. What action do you intend to take in regard to attorney?
I need one.
Pardon?
I need one.
I understand that. Let me quickly explain. You have an absolute constitutional right to an attorney. That's your right, all right? It doesn't
Yes.
happen automatically. You have to initiate some action. That right to an attorney means you have the right to go out and hire any attorney you want. And at that point, the court doesn't even get involved because you're arranging for a private contract between you and a private attorney. If you discover in that process that you cannot afford to hire an attorney, then you're still entitled to an attorney and one will be appointed for you. In order to secure appointed counsel, you have to take the action to fill out an application for the Public Defender's Office, and one will be appointed for you through the Public Defender's Office. So it requires your action either way in terms of your right to an attorney. You're charged at this time with the offense of possession of drug paraphernalia, Class D felony, and possession of drug paraphernalia for the manufacture of meth, which is a Class B felony. On those two charges, how do you now plead?
Not guilty.
I'm noting your plea of not guilty. I'm directing you to, if you're going to apply to the Public Defender's Office, to get the application filled out. Your case is on this court's docket. I'm going to set it by a scheduling order at this time, setting it for trial the week of August 20th, for a plea deadline on August 16th. You're to reappear for pretrial on May 31st, and I'm ordering you to reappear on May 3rd when we'll confirm that you have counsel in place and check on the status of the process, of the trial process. So all those dates will be in a scheduling order that'll be entered, been entered today actually, but it's your obligation to fill out and turn in that application for the Public Defender's Office if you're going to apply to attorney for appointed counsel. If you're going to hire counsel, then I strongly urge you to get about it. So that'll be the order of the court.
Thank you.
You may be excused.